Good afternoon and welcome to the British Institute of International and Comparative Law. My name is Christine Hausler and I will just say a few words of introduction before giving the floor to our very distinguished panel today. First of all, I would like to express our gratitude to Withers for having sponsored this event for the second year in a row. We're particularly grateful for them as we are then able to host the event in person as well as having a drinks reception after. So please do stay with us for this opportunity to discuss the issues further and to network. The reception will take place from around 7 p.m. onwards in the lower ground floor. So not on the ground floor, the lower ground floor. But I'm sure you will see some people that you can follow. So please join us afterwards as well. It's always, of course, a pleasure to be able to have an opportunity to look at the interaction between international law and domestic law. We've been doing that for a number of years. I know that Jill Barrett is joining us today, and she's actually the one who originally started this series. She's right here. So I just wanted to give her a nod because she was the one starting this series, and we are very pleased to be able to continue to host this event on a yearly basis. Of course, with thanks to Withers and special thanks to Dr. Robert Kovacs, who's with us as well. He is a honorary practice fellow with the Institute, so we're very pleased to have him and to have also another speaker from with us today. If you are interested in knowing a little bit more about the work of the Institute, especially our international law work, I would encourage you to sign up to our newsletter. The last one just came out. It's a quarterly newsletter that talks about all of our activities, our research, our events, such as this one, but also our training courses. So if you do know anyone who is interested in knowing a little bit more about international law but doesn't have much time, and we do have a lot of short courses that start in the autumn, of course, our flagship public international law course, as well as a number of other courses on climate change, energy law, migration, even cultural heritage. So please do spread the word if you know anyone who might be interested in joining us from September onwards. Now I will turn to our panel and our distinguished chair. It's my great pleasure and honor to introduce Lord Justice Dingemans today. We're very pleased that he accepted to chair this panel of experts. He, of course, had an illustrious career at the bar with a lot of experience of working in international law, international affairs, and foreign jurisdiction, including many other Commonwealth jurisdictions. In 2013, he was appointed as a High Court judge, and in 2019 at the Court of Appeal. Until very recently, he was also the lead judge for international relations, so a lot of international experience that even extends to having acted as a judicial officer at the Rugby World Cup. So I'm not sure if that will come in news tonight, but perhaps. And last but not least, I wanted to thank him for his engagement and support also of the work of the Institute beyond today, because he's also a distinguished member of our advisory panel on public international. So thanks to you, and over to you.
Kristen, thank you very much. It's a great pleasure to welcome you tonight. I was told 2 weeks out that it was a sellout, although obviously some are still to arrive. And that is not particularly surprising when you have 4 exceptional speakers that we have tonight who are going to cover a range of issues, immunities, and then going on in public international law. They're going to speak for no more than 15 minutes, and I will be my usual judicial sort of timekeeping that we have to do nowadays, as well as trying to work out what the right result is. And we're starting off with Professor Philippa Webb of 20 Essex Street. Philippa started her work as really a legal officer and special assistant to Judge Rosalind Higgins at the International Court of Justice. She was involved in 15 interstate cases there. She's now on a further 12 International Court of Justice cases, and that's about half the International Court's docket. So a complete expert in the field. She's also a professor of public international law at the University of Oxford and a fellow of Exeter College. So there could really be no one better to start. And Philippa is going to start also at the beginning with section 1.
Great, thank you so much. So Section 1 of the State Immunity Act lays down the rule of jurisdictional immunity and then places an obligation of inquiry on the English courts. The first paragraph of Section 1 provides that the state is immune from the jurisdiction of the courts of the United Kingdom, except as provided in the later provisions of that part. And the second paragraph of Section 1 adds that a court shall, note the mandatory language, give effect to the immunity conferred by this section, even though the state does not appear in the proceedings in question. Similar provisions to this section are found in the European and UN Conventions on State Immunity and in the legislation of Canada, Singapore, Australia, Israel, Pakistan, China, and South Africa. Two recent English cases have engaged with Section 1. In February of this year, Haeri Enterprises and Russia in the Court of Appeal, also known as the UCOS case, and just last week, permission to appeal was denied by the Supreme Court in that case. And in March, the Royal Embassy of Saudi Arabia and Constantine in the Supreme Court. And both cases raise the question of when is a foreign state special in the English courts? Because sometimes we treat the state like any other litigant, subject to our domestic rules of procedure and substance. But at other times, the state is special. Its sovereign status excuses procedural defaults or renders it immune from jurisdiction, even if it doesn't say a word in court. Now, I didn't know the Japanese embassy was going to be in the front row today, but I have a metaphor from Japanese mythology. There is a creature called the kirin in Japanese mythology. Now, sometimes the kirin appears as an ordinary creature that looks like a deer. And at other times, it reveals its true radiant form with shimmering scales and flames dancing around it. And I think the dual nature of the foreign state in domestic courts can be thought of in the same way. And the question under Section 1 is what triggers its transformation? So turning first to Haeri and Russia, this is when the foreign state was in its ordinary litigant guise. The Court of Appeal held that an exception to immunity from jurisdiction under Section 1 of the State Immunity Act can be established by issue estoppel arising from a decision of a foreign court. There had been 3 largely identical arbitral awards obtained by 3 claimant companies against Russia from a tribunal seated in the Netherlands. Russia then challenged these awards in the Dutch courts for a lack of agreement to arbitrate. The companies, meanwhile, commenced proceedings in the English courts for recognition of the awards under the New York Convention. And in 2021, the Dutch Supreme Court determined that Russia had agreed to arbitrate. So when the companies came before the English courts, they tried to rely on issue estoppel arising from the Dutch judgments to establish that Russia had agreed to arbitrate, which then fulfilled the arbitration exception under Section 9 of the State Immunity Act. Russia contended, among other things, that Section 1 of the State Immunity Act requires an autonomous determination by the court of the question of immunity on the balance of probabilities. And in Russia's view, the English court could not rely on issue estoppel to discharge that duty. Russia also said that as a matter of public policy, it would be wrong for the English court to outsource determination of a foreign state's immunity in England to the courts of another state, in this case, the Netherlands. Lord Justice Males, the other Lords Justice agreeing with him, accepted that Section 1 requires the English court to make a determination on the balance of probabilities. But he found that Mrs. Justice Cockerell in the court below had made such a determination that Russia had agreed to arbitration. And she did this by applying the substantive principle of English law that when the requirements for an issue estoppel are satisfied, the previous decision of a court of competent jurisdiction is conclusive on the issue in question. So in these circumstances, Russia was an ordinary deer, not a magical creature. Lord Justice Males held that the jurisdiction of the English court to examine the basis on which immunity is asserted and to determine whether it applies encompasses the imposition of whatever procedural rules are appropriate for that determination. And he added that on matters not expressly governed by the State Immunity Act, the court will apply its domestic law. On the public policy argument, he held that the court was simply applying the rule of issue estoppel as part of English law, and that this did not involve choosing between competing public policies. And he found that issue estoppel, in fact, was in accordance with the demands of justice, because, as he said, awards should be honoured without delay, even when against states. I now turn to the Supreme Court's judgment in the Royal Embassy of Saudi Arabia and Constantine, where the state was a magical creature, at least on the Section 1 issue. Now, the claimant had worked as a post-room clerk and then a secretary in the Cultural Affairs Department of the Saudi Embassy. When her employment was terminated, she brought a claim of discrimination and harassment on the basis of her Catholic religion. Now, Saudi Arabia had a varied approach to its participation in the various proceedings between the Employment Tribunal and the Supreme Court. It appeared in the Employment Tribunal and the Employment Appeals Tribunal. It did not appear in the Court of Appeal, but it filed a skeleton, and it appeared in the Supreme Court. And the Section 1 State Immunity Act issue was whether the Court of Appeal was permitted to dismiss Saudi Arabia's appeal for non-appearance, or was it obliged to determine the issue in the state's absence. Lord Lloyd-Jones gave the judgment, the other members of the court agreeing with him. He emphasized that to require a foreign state to appear before a court and inquire into its conduct would be a violation of sovereignty, and there is a duty on a domestic court to take the immunity point of its own motion. And he noted that Section 1(2) of the State Immunity Act didn't appear from nowhere. It actually reflected the common law rule, and it was incorrect to say that a sovereign must come forward and assert its right. He elaborated on what the content of that duty entails. The court is required to inform itself of the relevant circumstances of the case, and failure to take a point on state immunity of its own motion by the court may be a breach of international law. And he found that the duty of inquiry under Section 1 extends to appellate courts. This had been a point raised by the claimants. And he pointed to that mandatory language of shall. And he also noted that the word court is defined generously in the State Immunity Act as any tribunal or body exercising judicial functions. Lord Lloyd-Jones also rejected the claimant's argument that a foreign state should not be allowed a second bite of the cherry if it has breached procedural rules. He said that Section 1(2) imposes a clear direction to all courts that effect should be given to immunity, and this must be capable of overriding procedural rules. He found that Saudi Arabia's failure to appear in the Court of Appeal was not a breach of any procedural rule, and the fact that it raised an argument in the Supreme Court that had not been raised below, although not usually accepted for ordinary litigants, was permitted in this case. It's interesting to compare the Supreme Court's approach with other cases in which states have been permitted to breach procedural rules. In United Arab Emirates and Abd el-Ghaffar, the time for appeal of the UAE was extended, notwithstanding that it provided no excuse for its failure to comply with the time limit. In Karamba Koka and Kuwait was permitted to raise the issue of state immunity when it served its notice of appeal, usually too late in the proceedings. And in Egypt and Gamal el-Adin, the EAT admitted new evidence from Egypt, even if though this was against the rules. So there were precedents for this. However, the Supreme Court in Constantine noted that states don't have a completely free pass when it comes to procedure. It said that when a state has been afforded every opportunity to put before the court its case and evidence on immunity, but has chosen not to do so, then there was no continuing obligation on the English court under Section 1(2). And it referred to Mauritius Tourism Promotion Authority in Min, and a case that Hussein will speak to, Zhongshan, Fucheng, and Nigeria. So I want to conclude with 4 practical implications of these cases for immunity proceedings in the English courts. First, if a court exercises jurisdiction over a foreign state which is entitled to immunity, then that is a breach of international law. There is a duty on the domestic court, which is a state organ, attracting responsibility for the state itself to take the immunity point of its own motion. Second, we now have some guidance from these decisions on the nature and content of that duty of inquiry. It is an obligation of positive inquiry. The court has to satisfy itself. It applies to all levels of proceedings, including appellate. The obligation applies when the state does not appear. It also applies when the state chooses to appear, because a state cannot put itself in a worse legal position by appearing in order to assist the court. According to Hulley, issue estoppel can satisfy that duty of positive inquiry. Some evidence is needed to discharge that obligation. It's not quite clear what that evidence is yet. The Supreme Court said it would be evidence regarding the status of the defendant and the nature of the proceedings, and the proof is on the balance of probabilities. The third implication is that the State Immunity Act is famously described in Ben Caboose by Lord Sumption as a complete code, but that needs some unpacking. The State Immunity Act sets out the only circumstances in which a state may lose immunity from the jurisdiction of the English courts, but it doesn't say anything about the legal principles by which it is to be determined whether one of the exceptions to immunity applies. So where do we find these principles? Well, the State Immunity Act, we know from Alcom and Lord Diplock, falls to be construed against the background of public international law principles, but it's also to be read in the context of the common law, public policy, and the broader statutory scheme. And the fourth implication is, where do we draw the line between the state as ordinary litigant and the state as mythical creature? And just zooming out and going beyond the cases I've discussed, we start to have a typology emerging. So the state is treated like an ordinary litigant when we're dealing with commercial transactions, when we're applying for security for costs, when we have an issue estoppel, when property is in use for commercial purposes, when there are procedural time limits, although they are given some flexibility, and procedural rules that apply if the state has had every opportunity to raise issues of immunity. But the state is exceptional and different to other parties in that it has a presumption of immunity in Section 1, that there is a duty of inquiry on the court even if it does not appear, that service generally has to be via diplomatic channels, that injunctions are not permitted, that acts in the exercise of sovereign authority are immune, and that property in use for sovereign purposes cannot be attached or seized. I'm sure that some of the immunity cases that are still in the pipeline of our courts will add more detail and nuance to this categorization in the year to come. Thank you.
Philippa, thank you for that amazing start and for keeping on time. I didn't say at the beginning, one of the reasons for keeping everyone on time is so that you're going to have the opportunity to answer questions. And rather than the dreadful prospect of me having to ask a whole series of questions, please start working on your questions now. Our next speaker is Hussein Haeri, King's Counsel, partner at Withers, who, as Kristen has already said, have very generously sponsored tonight's event and reception. He's head of public international law and co-head of international arbitration at the firm. In 2024, he became King's Counsel and was the only solicitor advocate to take silk in that year, which was a fantastic achievement. He's a fellow at the Lauterpacht Centre for International Law at Cambridge and also a senior fellow on the international investment law at SOAS. And Hussein's going to deal with the case of Shongshan and Nigeria and enforcement of arbitral award.
Thank you very much. And I'm glad to discuss in particular, to start with, the enforcement of Zhongshan in the English courts, and then I'll go on to address also the enforcement in the BVI courts. Just to take context, there was a global enforcement of this investment treaty arbitration award. It had been seated in London. It was a $70 million award for, among other things, the uncompensated expropriation of an investment by Chinese investor Zhongshan in the Federal Republic of Nigeria. And as part of that global enforcement, there was the conservatory seizure of 3 airplanes in France, an airplane in Canada, and also conservatory seizure of properties in Belgium. But I'm going to focus in particular on the English enforcement. And in doing so, I'd like to address 4 issues that commonly arise in the context of immunity and the state. And Philippa has in fact addressed a number of them in anticipation, very nicely lining it up already. The first of them is the process with regards to the recognition of an arbitration award in the English court system and the timescales thereby. The second is service. The third is the commercial exception to the immunity that would otherwise apply for the execution against property of a state. And the fourth is the waiver of immunity from execution or consent to execution against property. And I'll address those 4 in turn. They are challenging issues for investors looking to enforce awards against states, but they do have some limits, as these cases illustrate. So to start with, in terms of the process, what Zhongshan did after Nigeria had failed to pay on the award is they sought and obtained an ex parte order in the English High Court recognizing the award as a judgment that was then served on Nigeria. They had the customary 2 months and 14 days after the receipt through diplomatic processes in order to come and challenge that ex parte order. They failed to do that in the timescale that was available. And belatedly, what they sought was effectively an extension of 6 months to make that application, because by the time they came to raise the issue, they weren't actually ready to make the application itself. So some 6 months was essentially sought. And in doing so, they relied on Section 1.2 of the State Immunity Act. And in particular, as Philippa has mapped out, the obligation on the court to essentially give effect to immunity, even though the state is not participating. And they said that in that assessment, there needed to be something more than the prima facie test for making an ex parte order. In that case, there had been evidence in support of the application that essentially under Section 9 of the State Immunity Act, because the enforcement related to an arbitration for which there had been consent, that the recognition should be given. Nigeria had in fact sought to challenge the award under Section 67 of the Arbitration Act on the same grounds, but had then withdrawn that challenge. That was also reflected in the application. That was also considered by the judge, Mrs. Justice Cockrell, in her ex parte order. But Nigeria said no, something more was required because of Section 1.2, that there ought to have been the direction of a hearing, even though they weren't participating, or alternatively, the judge needed to have satisfied herself based on the papers in the arbitration proceedings. Mrs. Justice Cockrell found that that was unworkable, that the Denton criteria for relief from sanctions were essentially at issue. There was a significant and serious delay. There was no good answer to that. And in all the circumstances, it was just to have the order made final. So there are some limits to the issue of Section 1.2 where a state is out of time without a good reason for out of time, as the court found in that case. That was affirmed also in the Court of Appeal in the summer of 2023, where Sir Julian Flo said that the argument that a state can simply miss and ignore a procedural timetable and that the court would necessarily need to follow a different process than the one that had been applied was as startling as it was misconceived. So we come on now to the second of the issues I wanted to address, which is service. Under Section 12 of the State Immunity Act, of course, there is service that's required through the diplomatic processes unless consent has been given. That gives rise to significant complexity in some cases. We saw that in the General Dynamics case with Libya in the UK Supreme Court back in 2021, for example. In this case, after having obtained the final order, we looked to enforce it. And we identified a couple of properties in Liverpool that were inhabited by tenants who were not related to the Nigerian mission. They were paying essentially commercial market rates for the tenancy. And so we got interim charging orders over those two properties. The first point that Nigeria took in that regard is that service, they said, needed to have been conducted through diplomatic purposes rather than on their solicitors in the proceedings. And Master Sullivan in the High Court disagreed in her judgment in June 2024. And she said, service relates under Section 12 properly to a writ or to an application commencing proceedings. It doesn't relate to an application such as this for interim charging orders within those proceedings. You don't need to go back to the beginning and serve again through diplomatic processes for that sort of an application within proceedings. So there are limits to service, and that's an illustration of it. I come on to the third point, which is the commercial exception for enforcement against a state's property. And here, what we're looking at in particular is Section 13(4) of the State Immunity Act. And it needs to be shown that the property is in use or intended for use for commercial purposes. We know from the Servas and Raffidain Bank case in the UK Supreme Court going back to 2012 that the historic commercial use of the property is not relevant or sufficient, at least, for this test. It has to be actually in use at the time or intended for use. That can be challenging to show when you're dealing with sums of money in particular because of the mechanism of Section 13(5) under the State Immunity Act. And what that provides for is that the head of the diplomatic mission in the United Kingdom of the state at issue can issue a certificate. And in that certificate, they can state whether that property is not in use or intended for use for commercial purposes. And where they issue such a certificate, it creates a presumption that it's not for commercial use. That is potentially rebuttable, but it is a threshold that needs to be overcome before it can be found that the property is in fact for commercial use. And that in fact was used in the Raffidain Bank case, that certificate. So it was here. So the head of the mission of Nigeria in the United Kingdom issued a certificate stating that these two properties in Liverpool were intended for use for diplomatic purposes and that they had tenants in them simply as a means to ensure that they were maintained in some level of maintenance for that intended use. One of the team went to the properties and essentially introduced himself, met one of the tenants, got information about the rates at which they were being rented out, and also that they were not in a very great state of keep. And there were various electrical equipments and so on strewn on the field in front of the properties. If you want more detail, Christopher Burks is in the room and will be with us for the drinks afterwards, and put in a witness statement to that effect, which Master Sullivan found effectively overturned the presumption that these were not for commercial purposes. And she found that they were being used for commercial purposes. The properties were being rented at essentially market rates. And so the charging orders were made final. I come on to the fourth issue I wanted to address, which is the waiver of immunity from execution of property. Of course, this is different from a waiver of immunity from suit, such as in an arbitration agreement or otherwise. And it is relatively rare that you would have a clear waiver of immunity from execution. Now, Section 13(3) of the State Immunity Act does provide for this possibility, however, where there is the written consent of a state to execution against its property. That's another basis whereby enforcement can be obtained and immunity would not apply, a separate basis, that is, to the commercial exception that we've just discussed. Many of you will know, in this room in particular, PNID is a BVI company that had an arbitration against Nigeria. They succeeded in the arbitration. The award was overturned in the English court, and there was an order for an advance on costs of £20 million to be paid by BVI to Nigeria in the context of that overturning of the award. So we sought and obtained an ex parte attachment of debts order in the BVI, where PNID is based, for the 20 million, with PNID being the garnishee of the amounts that it would otherwise have had to pay to the judgment debtor, which is the Federation of Nigeria. In the context of challenging that ex parte order, Nigeria said that the funds were not going to be used for commercial purposes. They were going to be used for sovereign purposes. So the commercial exception didn't apply. We relied instead on the provision in the China-Nigeria bilateral investment treaty, which said, firstly, that the award shall be treated as final and binding, and secondly, committed the parties to the enforcement of the award. And we said that the enforcement of the award must mean the execution against the property of the state, because otherwise final and binding would have essentially been conclusive. You wouldn't have needed this additional language of a commitment to enforcement. Judge Webster agreed with that, and he found that this language in the investment treaty was an effective consent for the purposes of Section 13.3 to enforcement against the assets of Nigeria. And in doing that, he relied on the General Dynamics case against Libya, and in particular, Judge Pelling's decision, since upheld in the Court of Appeal, in which he had found that the language wholly enforceable, albeit in a contract, amounted to a waiver of immunity from execution. I think what's particularly interesting and unusual in this case, however, is that it wasn't based under a waiver or consent in a contract. It was based in a treaty. It's a publicly available decision. You can find it. And I think it may be the only case in which there's been a finding under the State Immunity Act of a consent under Section 13.3. The reason it was under the State Immunity Act is because by an order in 1979, the BVI applied the State Immunity Act to that jurisdiction. And so it was the interpretation of Section 13.3 under the State Immunity Act that was at issue. And so the attachment of debts was made final accordingly. So hopefully the enforcement of this award illustrates these four important principles of process and timing, firstly, secondly, of the commercial, secondly, of service, thirdly, the commercial exception, and fourthly, the consent or waiver of immunity from execution. Thank you.
Thank you very much indeed. Interesting decision from BVI, whether it would be followed in the UK, different point. No doubt you can raise those issues later. But to carry on with the theme of immunity, we've got Professor Dan Sarooshi, King's Counsel of Essex Court Chambers. He is a Professor of Public International Law at the University of Oxford, and he is a busy practitioner on international matters. He was recently, but happily didn't have to do very much, appointed by the UK and EU to the panel of arbitrators appointed to hear Brexit-related disputes. More importantly, he is the co-general editor of the forthcoming 10th edition of Oppenheim's International Law, and he's going to be talking about immunities, particularly in relation to embassies.
Thank you very much, Lord Justice Dingemans. It's a pleasure to be here again for the BICL seminar. Thank you to Kristen for the invitation. It's a great pleasure to be here with Lord Justice Dingemans and friends on the panel. I must say, by way of introduction, first of all, I'll keep my time, given particularly your rugby background. I'm very keen. My sons play rugby, and I know how brutal it can be, so I shall try my best to stay within the time frame. But more importantly, I think the point is, over the years, that this seminar has become of increasing importance. And it's really quite remarkable over the 20, 25 years that I've been involved in practice of international law. The complete sea change and the complete turnaround and the way in which international law is treated in the English courts with the consequence that it's now such a busy area of practice that you have, departments within law firms, you have practitioners at the bar who specialize in this. And it's not just the people you see before you, it's tens of barristers, if not more, who specialize in this field, and it gives them a daily job, which is quite a remarkable thing, given the large volume of cases that now involve international law aspects that regularly appear before the English courts in a way that simply didn't happen when I was sitting at the feet of Rosalind Higgins. I hate to mention how many years ago, but it was a good 35 or so years ago. Everyone was very excited about the Bryn case, which none of you will know. Some of you may know. That was the one kind of House of Lords case. And now there are, the Supreme Court has published a booklet, which I would encourage you all to read, on public international law in the Supreme Court in the last 10 years. And it's remarkable. That's only a slice of the cases. I think there's 10 cases in that publication. It's only a slice of the cases that have gone before the Supreme Court. There are, every year, I'd hasten to guess, around 30 to 50 cases involving international law in the English courts now. So it's very encouraging for those of you who are thinking about a career in this area. I'd encourage you to pursue it because, of course, it's a great testament to the power and authority of international law now, because actually international law, by being applied by domestic courts, in many ways, that's an evidence of it being taken the most seriously that it can be taken, because it's being given binding effect by the domestic courts. It's not always given effect in the way one would hope as an advocate of international law, but it's still very important in practice. So I just wanted, by way of introduction, to say that, because I think it needs to be recorded, the complete remarkable growth that's occurred in this area. And just in preparation for this, I had a quick look in the last year in Westlaw, and just a brief search on State Immunity Act came up with, I think, around 35, 40 cases. That's just in the area of state immunity, let alone all of the humanitarian laws of war and the wide range of cases that exist. So coming back then a bit more specifically to my topic, and I'm now conscious of my time. We have, I've been allocated amongst us to deal with a few cases which deal primarily with Section 4 and Section 16 of the State Immunity Act. Section 4 famously contains, you will of course know Section 1, as Philippa has clearly outlined, contains the general rule of immunity. Section 4 contains the exception to, one of the exceptions in relation to contracts of employment, where that contract of employment was either concluded here in the UK or where the work to be performed is to be in the UK. And those are the two, that's the requirement of Section 4. But then there's famously exceptions to the exceptions. And the exceptions to this exception to Section 4, where, in other words, immunity continues to exist for the state, where the person suing the state is a national of the state concerned. This is, at least previously, was the position under Section 4, or where the claimant was neither a UK national nor a UK resident. So it was quite limited, the scope of this employment exception previously in the State Immunity Act. Now, what I want to briefly get into with you today is the series of cases that have actually disapplied, in other words, abolished in practice, this immunity for states in the UK. And the famous case, of course, has already been referred to, of Ben Kabush and Jana, and I was involved in that case. It was a hard-fought case, but essentially, I won't go through the detail, but essentially the test that case, the Court of Appeal of the Supreme Court established, was the following, because it involves, of course, let me just say that immunity involves a clash with the human right of access to a court under Article 6 of the European Convention on Human Rights, which is incorporated into the UK by the 1998 Human Rights Act. And so you have then a potential clash between this right of immunity of the state under Section 1 And you have then the right of the individual to access to the court under Article 6 of the Human Rights Act, incorporating the European Convention. And how should this be resolved? That was the central question which the Benkebush and Benkebush and Jana cases established. And the test is the following. If the UK is required as a matter of obligation under customary international law to grant immunity to a state in particular circumstances, then the breach of the right of access of the individual is justified. So essentially, cutting through all of the legal argument and discussion, the question is the UK, as a matter of customary international law, required to afford a foreign state immunity in a particular case? And that's the test that will be used to adjudge now all of the provisions of the State Immunity Act. It's quite a remarkable and broad-ranging judgment, the Janet Benkebush judgments. And that was applied in one of the cases that I will now discuss that arose last year, the Lorenzo and Spain case. Sorry, I should say, as a result of Benkebush and Jana, the Court of Appeal and the Supreme Court disapplied the State Immunity Act in relation to Section 4.2b. That was one of the elements. I remember I said, if you're a foreign national or not a UK resident, then you can't sue the foreign state. And that's most relevant for embassies, where embassies have employees in the UK. And that was disapplied. So the Supreme Court and Court of Appeal said that rule does not exist under customary international law. There's no rule of nationality in that way that exists. So you can't limit the scope of the employment exception in that way. That was the first thing they established, and that was applied then in the Lorenzo case last year, Lorenzo versus Spain, a case brought by Ms. Lorenzo against the Spanish embassy, where Ms. Lorenzo said that the Spanish embassy had violated a number of employment rights, but Ms. Lorenzo fell into not 4.2b or 16.1a, which is what the Supreme Court disapplied in Benkebush. Ms. Lorenzo fell under 4.2a, which was the remaining element that had still not been tested. And 4.2a was the one that said, if you are a national of the foreign state, so if you are, in this case, a Spanish national, then you can't sue the Spanish embassy. That's the effect of Section 4.2a of the State Immunity Act. And once again, in a remarkable judgment, in fact, it was Mrs. Justice Ellen Bogan in the EAT, Employment Appeals Tribunal first, and subsequently the Court of Appeal. They said there is no such rule of customary international law that requires the UK to afford immunity in this case relating to a national not being able to sue their state of nationality. And so once again, that was disapplied. So once again, there will have to be another further amendment to the State Immunity Act to actually change that provision in the State Immunity Act. Moving swiftly on, there was another case, another employment case, important case involving Dowling versus United States. And this case, Mr. Dowling brought against the US Embassy here in London. And Mr. Dowling was a UK citizen. He was a motor pool supervisor. And the question became, in application of the Benkebush test again, whether or not Mr. Dowling was performing the sovereign functions of the United States by the performance of his employment activities, which in this case was as motor pool supervisor. We were able to establish that, in fact, he was performing sovereign activities of the United States. And this follows a long line of cases, all of which have happened in the last 5 years, involving firemen and women, office administrators, and so on, which as a result of the Benkebush test has thrown now the case law back onto the question of whether or not these individuals who are trying to sue their foreign embassy or in fact the state are performing sovereign functions of the state involved. And that's the common law test, which Lord Sumption said is the customary international law test. to decide whether or not a provision of the State Immunity Act survives the right of access to the court, whether or not they are, you know, the classic ure imperio, ure gestionis distinction. So all of the cases now, it's going to be a common function of all of these cases that they will be examining that, which requires, of course, establishment of whether particular functions are being performed as part of the sovereign activity of the state. The final case I would briefly mention is the case of Alatiki. And this is interesting because it involves the Kuwait Investment Authority. And the Kuwait Investment Authority is the oldest, in fact, it's the oldest sovereign wealth fund that exists. And it was given special status in the UK. It established very early an office in the UK, the Kuwait Investment Office. And it was given a special status where it was almost treated as if it was part of the diplomatic mission of Kuwait to the United Kingdom. So it was really quite a special status. And there were 22 diplomats who technically were diplomats accorded diplomatic status who are assigned to work for the KIO, this Kuwait Investment Office. And the question in the KIA, the Alatiki versus KIA case, raises a novel and very important question of whether or not, last minute.
Whether you've got 2 more minutes.
Oh, thank you. Thank you. I thought that was the judicial look I sometimes receive. Thank you. The question that it raises is whether or not the exercise of these diplomatic functions, sorry, Mr. Alatiki's role as a diplomat, he was actually accorded diplomatic status, whether that meant he was engaged in the exercise of sovereign functions on behalf of the state, and so, or whether or not he was carrying out activities in a private capacity because of what the Sovereign Wealth Fund did. The Sovereign Wealth Fund, of course, invests, and he was the CEO. Mr. Alatiki was the former CEO of this wealth fund. Now, rather unsurprisingly, I think the employment tribunal in this case found that Mr. Alatiki was engaged in the exercise of sovereign functions because, of course, he was a diplomat. But it's more complicated than that because what this case also is interesting for is the question whether the KIO forms part of the state of Kuwait and so can benefit from state immunity. And this goes to construction of Section 14 of the State Immunity Act, which defines what is a state for the purposes of application of the State Immunity Act. And the key issue there, which has been decided by the Privy Council in the famous Dingemans or the FG Hemisphere case, rather remarkably says the following. It says that where an entity has been established by law in the foreign state concerned, so in this case, Kuwaiti law established the KIA as a separate entity from the state itself, and where that entity can sue and be sued in its own right, then that entity is not part of the state and so does not enjoy state immunity. That's fine as far as it goes, but the real question is in what circumstances can that apply and does that not apply? And this is where our courts have been quite remarkable in their finding on this. And just by way of conclusion, I would say the following. In the case of FG Hemisphere, the Dingemans case, the Privy Council established that there is a strong presumption that where these two elements exist, that a separate entity cannot be or should not be considered as part of the state. A strong presumption. And then the question is, well, what does a strong presumption mean in practice? They went on to say, make some references to a sham entity, although it wasn't clear exactly how that was going to be used in practice subsequently. But this was clarified by the Court of Appeal and then the Supreme Court, although it was really the Court of Appeal in the case of SOMO versus Iraq, where SOMO was the state oil marketing organization of Iraq. It generated 92.66% of the entire Iraqi national budget because it was the only government entity that was allowed to sell oil on behalf of the Iraqi state. So basically, its activities funded the entire Iraqi state. It did not pay tax. It was run by nominally a separate board, but the Minister of Oil and many government ministers sat on that board and made decisions. And even in that situation where it didn't pay tax and everything I've said, the Court of Appeal said that this application of the strong presumption meant that SOMO should not be treated as part of the state, and so could not enjoy state immunity. Quite a remarkable decision. So in conclusion, the English courts are very heavily engaged with issues of state immunity. They are narrowly construing the scope of application of state immunity so that now states are more exposed than ever to suits. And they are also doing that not only by construction of provisions of the State Immunity Act, but they're doing it by definition of what constitutes a state. Thank you, Lord Dingemans.
Dan, thank you very much, and thank you too for the sort of journey around the immunities of embassies. I mean, I've always thought a strong presumption means you're likely to lose. But then we turn to our fourth speaker, Professor Yeginsu, who's a barrister at 3 Verulam Buildings. He's also a member of the law faculties at Columbia Law School in New York and Georgetown University in Washington, as well as the University of Law School in Istanbul, a fellow of the Lauterpacht Center for International Law. But his true claim to fame is that he was appointed to the high-level panel of legal experts on media freedom and succeeded Amal Clooney as the deputy chair of the high-level panel. And Jan is going to take us away from immunity.
James, thank you very much. I thought the true claim to fame was being co-author of a book with you, but there we are. Thank you very much indeed to Bickel for this invitation. What I'm going to do in my remarks is just depart somewhat from the focus on immunities and enforcement and touch on several other areas where we've seen the English court in the last year or so grapple or choose not to grapple with questions of international law. And I want to do that in the time available to me by reference to 3 cases, each case arising in a very different legal context. We'll start with international investment law, we'll then move to constitutional law, and we'll end up with a decision from the first-tier tribunal in the immigration context. The reason for really picking these cases is because, as Dan says, there are a whole host of reported cases on state immunity or enforcement. You see that, but you also see a whole host of cases every year arising in different contexts. And I want to just give you a taste what we saw over the course of the last 12 months or so. So let's start with investment law, international investment law, and a case that will be known to the investment lawyers in this room, Czech Republic and Diag Human and Joseph Stava. Now, this was a long-standing dispute. It ended up in the Court of Appeal this year, but it predates that hearing and judgment by several decades. It was originally an arbitration brought by a Swiss investor under the Czech-Switzerland bilateral investment treaty, and it was a arbitral proceeding that was proceeding under the UNCITRAL rules, and it was seated in London. It gave rise to a rather substantial award, around $350 million, against the Czech Republic and in favor of Mr. Stava and his investment vehicle. And that award was subject to challenge in the English courts under Section 67 and Section 68 of the Arbitration Act 1996. We can leave Section 68 aside for present purposes because there's no question of international law arising there. In any event, it was unsuccessful. The proceeding so far as Section 67, or that challenge by the Czech Republic, is concerned, much more interesting Of course, under Section 67, that's the ground on which you can challenge an award on the basis that a tribunal lacked substantive jurisdiction. And there, the English court will conduct a de novo review. And that sometimes involves the English court essentially interpreting an investment treaty afresh. And in this case, it involved first the English Commercial Court and then the Court of Appeal looking at this bilateral investment treaty and in particular definition of investor, the approach to standing and the scope of the state's offer to arbitrate under the BIT. Now, this challenge led to two different decisions from Mr. Justice Foxton sitting in the Commercial Court. He essentially dismissed the challenge and held that the tribunal had jurisdiction over both Mr. Stava and his investment vehicle, Diag Human. The Court of Appeal upheld Mr. Justice Foxton in large part, but decided that he hadn't got the definition of investor quite right. And that led to the Court of Appeal essentially setting aside the award in part, especially as it applied to Diag Human. Now, it's sometimes said, I think perhaps too readily, that the Commercial Court approaches treaties as if they were just another form of commercial contract. And I think that criticism is probably unfair. And it absolutely cannot be a criticism leveled at either the decisions of Mr. Justice Foxton or the decision of the Court of Appeal. There are really two key questions of treaty interpretation in this case. The first was whether Diag Human qualified as a covered investor after 2011, and that was when Mr. Stava no longer had legal control over Diag Human. And that was relevant because the underlying bilateral investment treaty was one of these treaties that extended coverage to legal entities established under the law of any country which are directly or indirectly controlled by nationals of that contracting party. And that, of course, gave rise to the question of what does control mean in the context of the BIT? And in particular, is de jure control required, so legal control, or is de facto control sufficient? And that was the question on which essentially the two courts parted company. Mr. Justice Foxton found that on a proper interpretation of the treaty, de facto control permissible, gives you covered investor status. The Court of Appeal disagreed and found that on a proper construction of the treaty, de jure control was required and de facto control was insufficient. The Court of Appeal went on to find that even if they were wrong on that point, that on the facts, Mr. Stava did not have de facto control anyway, so it wouldn't have changed the overall result. But the reason this case is interesting in my view, I mean, we as investor states or practitioners are having to run arguments of covered investor, covered investment all the time. But we do that usually in front of investment treaties and not in front of the Commercial Court or the Court of Appeal. And what you have here are three very detailed judgments where counsel are running very similar arguments, the sorts of arguments they would run in front of an international tribunal. And the English court is directly applying international law. It's interpreting the underlying bilateral investment treaty by reference to the Vienna Convention. It is hearing submissions by reference to sort of various decisions of investment tribunals and so on. So here you see a very direct engagement. Now, move to a very different kind of case and a very different kind of approach by the English court. And I want to just touch on a case of the administrative court. This is the Crown on the application of FDA and the Minister of the Cabinet Office. This was, I think, fascinating a case arising out of the Conservative government's Rwanda policy. The Cabinet Office had issued a guidance in April 2024 to civil servants about their obligations under the Civil Service Code. Now, some of you in the room will know, especially the public lawyers, that the Civil Service Code contains an obligation on civil servants to comply with the law and to uphold the administration of justice. And what this guidance was doing was purporting to deal with the implications of that obligation on civil servants in a hypothetical scenario. And the hypothetical scenario was this: if the European Court of Human Rights were to indicate to the United Kingdom by reference to a Rule 39 interim measure that an individual should not be removed to Rwanda pending the final determination of some legal procedure, whether that's a domestic proceeding or an international proceeding, but where a minister decided to proceed with the removal notwithstanding, where did that leave the civil service? And the guidance said that in implementing that minister's decision, i.e. a decision not to comply with a ruling of the Strasbourg court, civil servants, would be acting in accordance with the code. Now, that guidance was subject to judicial review, and the judicial review was brought by the FDA, which is one of the civil service unions. They said the guidance was wrong in law because the code requires civil servants to comply with the law, which means both domestic law and unincorporated international law. The matter went before Mr. Justice Chamberlain, sitting in the administrative court. And what he really had to do was, in effect, grapple with the legal effect of a hypothetical ministerial decision to breach a Rule 39 indication from Strasbourg. And that really gave rise to three key questions. The first is a Rule 39 interim measure binding in UK domestic law? The answer to that from the court was no, unless incorporated by statute. Rule 39 interim measures create no enforceable legal duties on ministers or civil servants. Issue 2, did the guidance contravene the code or constitutional principle? Again, the answer no. The code does not entrench international legal obligations such as Rule 39, and civil servants is really important, remain accountable to ministers, and legality must be judged by reference to domestic law, not unincorporated international law. And finally, issue 3, what is the proper scope of the obligation to comply with the law under the code? And Mr. Justice Chamberlain was very clear in his judgment that the law extends to international law, but not to international law that conflicts with domestic law. So this is a classic reaffirmation of the dualist theory of international law, the idea that international law and domestic law operate essentially on different planes or on independent spheres. So that as a matter of international law and accountability, the UK would obviously be in breach of Article 34 of the Convention if it didn't comply with a Rule 39 indication. That would be a breach of international law. But because Article 34 of the Convention is not incorporated into domestic law, it does not in fact bind the executive as a matter of domestic law. Only Parliament can give international law direct effect. And there was a very, I think, strong exchange on whether or not the strong domestic convention that the government will act in compliance with the UK's obligations under international law was in play or not. But it was clear to the administrative court that that presumption doesn't apply where there is a statutory provision ousting the underlying presumptions. So just sort of, by way of closing, because James told me I have a minute left, two very different approaches. So judges undertaking two very different exercises. And the third judgment I wanted to touch on was a very interesting decision from the first tier tribunal engaging Article 10 and whether or not a decision from the Secretary of State to cancel a student's permission to enter the United Kingdom was proportionate as under the convention as a matter of the Human Rights Act here. The reason I wanted to touch on that is, there's a lot of discussion on the way in which the higher courts have to apply international law, whether it's directly or indirectly. But the reality is that there are a whole host of statutory tribunals that are being asked to apply international law, as we've also just heard from Dan. Thank you very much indeed.
Well, Jan, thank you. And thank you all for four excellent introductions, speeches, perspectives on this. We're now got 20 minutes for questions. Please, can you put up your hands? Can you say what your name is and can you ask your question very shortly?
Hi, Cameron Miles, 3 Relevant Buildings. I've got a quick question for Hussein about the general dynamics decision as implemented in PNID. The sense that I have is that that decision could potentially be quite problematic, and I welcome you allaying my concerns, because previously we had a regime whereby if you were having a waiver of enforcement immunity, you usually had a specific claimant and a specific asset in mind. And if you've got sort of general waivers sitting around in investment treaties, you now have a waiver that is completely general over any assets within the jurisdiction. It's over a completely undetermined class of claimant and can last years into the future, or decades even. And it's general, as I said, over all assets within the jurisdiction, even those that are in sovereign use. So it seems to me that this could end up in a situation where pretty sensitive assets for extremely sensitive sovereign purposes could be subject to general seizure for potentially billions of dollars, depending on the size of the award. And I've got in mind in particular the gold that's sitting in the Bank of England, that is the currency reserves for a large number of states, which ordinarily would be protected under central bank immunity, but that just says that they're deemed to be in use for non-commercial purposes, and the waiver cuts right through that. So am I wrong about that, or is a whole new class of enforcement action about to open up that could potentially do damage to states and also to London as a safe house for currency reserves and deposits?
Thanks very much. I think it's an excellent question. So this wouldn't address the issue of central bank immunity or diplomatic immunity. Those would continue to apply. That wasn't at issue, and this wouldn't derogate from that necessarily, from those legislative frameworks which sit outside the State Immunity Act. So this was for the purposes in particular of Section 13.3 of the State Immunity Act, but obviously there is different legislation, as you've alluded to, dealing with immunity from central bank assets and also from diplomatic assets. But I think your point that there is a wide-ranging implication from this is certainly I would agree with. The question becomes really, what does a consent or a waiver of immunity from enforcement mean if it doesn't relate to execution? What Nigeria sought to argue is that enforcement and execution are different things. They're dealt with differently under the ICSID Convention, for example. And so even if you are committed to enforcement, that doesn't necessarily mean that you're committed to execution. The judge in this case didn't agree with that, though. He said that the ICSID Convention and dealing with it was in a different context. And if that distinction had been sought to be made by the states parties to the treaty, they could have drawn that distinction themselves. So I think his conclusion really rested on the finding that enforcement must impliedly mean execution, and also something more than final, because the award was already required to be recognized as final and binding.
I think Philippa wants to. Yes.
I just wanted to add on that there's about 8 states now that are happy to have a double waiver that includes the waiver of against property that's in use for sovereign purposes. It hasn't yet gone as far as diplomatic and central bank, but there is a sort of trend in this area. And it's interesting, the slippage in language here between committed to enforcement and wholly enforceable. I think they're not the same, but they were treated as such. So it's definitely a trend to watch.
Yes, thank you. Thank you, James. Yes, as you say, Cameron, right, quite rightly. I mean, you know, the General Dynamics case it is remarkable because it's not remarkable really. All it's really saying is the phrase wholly enforceable in a contract means, for the purposes of the State Immunity Act, that constitutes a waiver in relation to what the immunity would be from enforcement. Of course, for those of you in the room who are not specialists, we have both adjudicative immunity, which means that the courts, that considers whether the courts can in the first place hear a case involving a state. And that's what sections 2 to 11 of the Act deal with. But then you've got a separate regime relating to enforcement against the state's assets. And sometimes it's used a little bit interchangeably, enforcement and execution. It's a bit more precise than that. We don't have time to get into that unless you have a question. But the point is that there's a separate regime. So just because a state may fall within the exceptions to adjudicative immunity doesn't mean that the state's assets and property can be enforced against in the UK. And what the General Dynamics and Libya Court of Appeal decision, the most recent one of February 2025 decided, was that a phrase wholly enforceable in a contract effectively between a state and another party, in this case General Dynamics, that constitutes a waiver for the purposes of the enforcement regime. And that's quite a big deal, because usually state property, as Cameron was alluding to, is well protected, because the test is whether you can establish that the property is commercial, in other words, is not intended for use, or is intended for or actually being used for commercial purposes. So that's where this new case actually is quite important in moving things along in terms of the scope of cases now that can be brought against state property where you've got a provision in the contract. Thank you.
Yes, at the front here.
Taha Al-Masri, I'm a PhD candidate at the University of Oxford. 2 questions, if I may. The first for Professor Sarooshi. As I was reading the Dowling decision, I saw that the tribunal twice characterized the claimant's role as motor pool supervisor as of systemic importance to the US mission. I wonder whether that was a formulation that you had argued for in submissions, and whether it might be relevant in future cases to answering the question of sufficient closeness to the government or sovereign functions of the state or diplomatic mission. The second question to Professor Yeginsu, and it goes to the point which you made about the difference between making arguments before a treaty tribunal, investment treaty tribunal, and before the commercial court or the Court of Appeal. I wondered whether there's something to be said for the difference in approach to investment treaty jurisprudence or the previous treaty awards, because we saw that in the commercial court judgments, Mr. Justice Foxton placed considerable weight on that jurisprudence, and he conducted an extensive review of the awards. That didn't follow on at the Courts of Appeal, where they found that exercise neither necessary nor helpful, and chose instead to emphasize that there is no rule of precedent in public international law, and the awards are only valuable if the reasoning is cogent.
Dan, do you want to go first?
Sure. Thank you. Thank you, Tara. Obviously, you've been taught well. On Dowling, I won't get into what was argued or what not. I mean, you know, the judgment stands for itself. But what I would say is that I don't think it's necessary to answer the substance of your question. I don't think it's necessary to have to establish that someone is engaged in the performance of a systemic function in order to find that they are engaged in the performance of sovereign activity on behalf of the state. I think, really, I think what the judge was referring to there was the fact that this individual was actually performing functions in relation to different departments within and interacting with different departments within the embassy. And I think that's the point, that it's a very case-specific, fact-specific inquiry always. But I think to answer your question, that's the specific thing. The interesting line of authority that's emerged from this, but also from an earlier EAT set of decisions in Wright and Webster, is that it's actually not only the function, but this is Benker Bush 57 to 59, paragraphs 57 to 59, where it's now also potentially where an English court has to investigate the application of a foreign state's policies, where in a particular case, a foreign state has a policy, for example, a directive that's applied to all embassies, to all military bases, and where a particular individual within the embassy or military establishment has applied that policy, then there's a line that's been drawn to say that the English court should not engage in detailed consideration where it would require investigation of the application by the foreign state of that policy, which is an interesting spin. And as I say, it has roots back in Holland and Lamp and Wolf, but more recently it's been stated in these EA2 decisions. Thank you.
Yeah.
Thank you very much for the question, which you have partially answered, making my life easier. I mean, it is, I think, as counsel, I think one does take a different approach. Those on the panel in the room who do investment treaty arbitration will know that some parties' representatives like to, submit very long materials, many hundreds of authorities on the definition of investor or investment, obviously decisions which were interpreting different treaties or different provisions in different treaties and therefore of limited value. I think the Court of Appeal's approach to all of this was, look, even on its own terms, there's no doctrine of precedent in investment law. So some of these authorities are interesting, but they don't even bind other investment tribunals. So that's sort of point one. Point two, we've had a lot of authority cited at us, but when you look at these decisions, the underlying treaties are different and they use different language when it comes to the definition of covered investor, which was the issue in that case. And I think the major difference between Mr. Justice Fox and the Court of Appeal was how much weight was given to a protocol that had been concluded at the time of the treaty. And I think the Court of Appeal probably felt not enough by Mr. Justice Foxton. But again, taking a step back, it's a very good example, a reminder that the approach before investment tribunals may not necessarily be as effective in front of an English judge.
Right. Next one question.
Yeah, and with that.
Sagar Gupta from Squire Patton Boggs. My question is on the impact of the decisions of the English courts interpreting these treaties, and that could be the Nigeria case or Diag Human. But do you think investment tribunals or indeed other tribunals are going to take notice of these decisions, and what might be the impact of these decisions on arbitral decision making? Because again, obviously there's no doctrine of precedent, but will they take notice? And sort of a second part of the question is, say for example, in the Diag context, will the answer be different if the tribunal is seated in London? And therefore, would you actually advise a client not to seat in investment arbitration with similar wording in London at all?
You want to go first and then Sam?
Sure. I mean, I think it's again going to depend in part, at least, on the formulation in the treaty that's being interpreted. If it's very similar or the same to that being considered by an investment treaty tribunal, then yes, they may well look at how an English court has construed the same or very similar provisions, particularly depending on the constitution of the tribunal and possibly where the arbitration is being seated. So there is a scope for that being considered in the right sort of context, depending on the language potentially.
Yeah, I mean, the flippant answer to your question is that a barrister is never going to advise client not to seat an arbitration in London. But the serious answer to your question is that I think it's really a matter of legal culture, in that, as you well know, the constitution of the tribunal is key in any given investment arbitration case. No doubt, for some investment arbitration tribunals, the judgment of the English Court of Appeal will carry considerable weight when it comes to interpreting that specific provision in that specific treaty. And before other tribunals, it will carry less weight. But of course, I mean, this was a very, very specific decision on a specific provision, where there was a degree of ambiguity in the language of the treaty, and therefore I think of limited application more broadly when it comes to the jurisprudence of covered investor.
Just a broader point on the UK State Immunity Act and the influence of English court decisions. And I think they have a really significant influence in other jurisdictions and before international courts and tribunals, because the State Immunity Act was the second oldest legislation, 2 years after US Act, which is quite quirky. And then a lot of Commonwealth states copied the language. So there's already a basis for following. And then the UN Convention, which is not yet enforced, but is commonly referred to by judges as a codification in some areas, is also based on the State Immunity Act.
Right, there's time for one more question, because after that question is answered, I'm then just going to ask each of the panelists to say their concluding remarks, and then we'll finish at 7 p.m. and then we'll go and celebrate with the generous drinks sponsored by Withers. So the last question. God, that shouldn't have put you off. No one? Well, in which case I will ask
The order in which they've spoken to go.
Okay. So I would just say that the theme of all of these cases is that state immunity is alive and well in the English courts, and it's quite a dynamic field, despite our underlying statute being from 1978. And it makes the advice of counsel all the more important in terms of how do you phrase your waiver, how do you serve this document. So I think, in this jurisdiction and beyond, we're definitely the courts to watch.
Yeah, just to echo that, and to say that there are a number of advantages built into the State Immunity Act, of course, for states, such as no injunctions against states, such as the certificate process with regards to whether property is commercial, at least in the first instance. But there are also some limits, and I think what some of these cases show is that there are circumstances in which enforcement can be done effectively against a state, notwithstanding those parameters in the State Immunity Act.
Yeah.
There are some exciting and interesting cases coming up involving alleged hacking and the extent to which that can fall within an exception to state immunity. So there's, this is an ever current field. And but as I said, I think my conclusion was that the scope of immunity is being narrowed by the courts.
Thank you very much. And just to, I think really to reiterate a point, or make it expressly in a way I think I implied earlier, which is that public international law is relevant to a whole host of different cases arising in different contexts, etc. But I think counsel have to be very, very careful when it comes to deciding how to address the court by reference to international law. What do I mean by that? There will be some cases like Dyack where you are asking the court to interpret a treaty quite directly, and you'll be making submissions under the Vienna Convention. You'll be providing a whole host of international legal materials. But the decision of Mr. Justice Chamberlain, albeit in a completely different context, is also a warning. Don't get ahead of yourself. This is not a monist system. And one needs to take a step back and understand the context in which the points of international law arise. And that's a very, very important nuance, especially in front of the administrative court.
Well, can I just conclude with a short remark on that? We are in a dualist system in the courts in England and Wales, but there are many areas of law where we are required to look at public international law. And may I say that's a great privilege, because some of my practice was in that area. And it is fantastic that there are so many fresh faces looking interested in this area, which is a vital area for the future development of the law. But anyway, enough of that, because it's now my pleasure to ask you to thank the panel for 4 exceptional speeches and answers.